each week. And today we also have our superstar panel, attorney Vanita Banks, expert in cybersecurity law, master's in tax, and also Milton from LA. Before I get started, we had some significant Supreme Court decisions this year, but the bombshell got dropped again this week. And the first issue I want to talk to you about is the affirmative action ruling. And I think that because the terminology that I see on TV, they're not properly explaining what affirmative action is and why it came into existence. In essence, now I'll give you a quick synopsis of how this came into being. I attended the University of Georgia Law School, and the University of Georgia Law School, and this is a typical problem in America, right? So the law school was founded in 1859, but when the University of Georgia Law School was founded, it was founded for white residents, or white students. And so this permeated the University of Georgia Law School for over a century. And the reason that's important is you could be the top student in America, but if your color were Black or you're African American, you would never have been admitted to University of Georgia Law School. And so in the 60s, they admitted a gentleman named Chester Davenport. Chester Davenport was a brilliant student, and the whole time he was at the University of Georgia Law School in the 60s, he was the only Black in the law school. I came along in the towards the end of the 70s, and to give you a good idea, there was maybe 220, 230 students admitted, and they were admitted somewhere between 7 and 10 Black students, and that's it. And that's how law school actually admitted Black students. So it wasn't based on the fact that you had deficient scoring, because all the people that actually apply to law school, the majority of those folks meet the qualifications, but because of the color of your skin, you weren't admitted. But the University of Georgia then started admitting students, and they enacted an affirmative action program. And so all they did is that if two students had the same grade point average, 3.5, and the same test scores, then they would give preferential treatment to make sure they had a few Blacks in the class. But there's always been affirmative action for white students, even today. So the Supreme Court decision that ended affirmative action to try to make sure we have some representation of Black students, like, for example, in the law school, probably about 1% of the students in the law school nationwide are Black students. So it's a very small percentage. 2% top. I didn't look at the numbers today. But the problem that bothered me about this case is the court doesn't properly recognize why, under the Nixon administration, they started this affirmative action in the first place. And then what was disturbing about it, they introduced a new term that I've seen in the law called race neutral, that they made a part of this decision. And it was articulated by Clarence Thomas, who a lot of people think is morally legal corrupt in terms of taking gifts from billionaires. But the separate but equal meant that we could have segregated schools and have less resources than white schools. Well, now they say race neutral is what they're trying to get, but the decision is anything but race neutral. When you read the lengthy decision, I didn't get through the whole decision. I read the summary of it. I started reading the decision. And they go through all the cases. But the thing that stuck out about this case is that they continue to use the term race neutral. And that, I disagree with that, because what they're doing is not race neutral, but that's a point of beginning. Attorney Banks, you get a chance to look at any of that decision?
It's quite a lengthy decision in which everybody knows at this point the U.S. Supreme Court in a 6-3 decision reversed the longstanding use of race as a factor in college admissions. And initially, there's a question that whether or not the plaintiffs even had standing to bring this suit. It's an organization called Students for Fair Admission. And the question was whether or not it was a membership organization that would have standing to bring this suit. But this issue goes back to 1978, the Bakke decision, which stated that, and Justice Powell wrote the 5-4 opinion in the Bakke case, which stated that race could be used as a factor when choosing among qualified students, that race could tip the balance in those situations. So let me just go back and talk about this term, quote, affirmative action. That term was never intended or established to stand for a proposition that unqualified students or applicants for employment should be admitted to law school or obtain a job. It was intended for individuals that had been systemically discriminated against for all the reasons that you stated, Attorney Lee, to have the opportunity to get in the door in order to prove themselves. So in this case of Harvard Law School and the University of North Carolina, these are qualified students that have met the admission standards. So in Bakke, that case, the court held that because in that case, 16 seats, were specifically set aside for minorities to law school, that policy was struck down. But Bakke also held that race could be used as one factor among many factors. The issue came up again in 2003 in the Grutter versus Bollinger case, in which Sandra Day O'Connor wrote the opinion and stated that diversity is a compelling state interest and that a race-conscious admission standard, which is narrowly tailored to avoid unnecessarily disadvantaging other applicants, could withstand constitutional scrutiny. And so she did also state in that case that she was hopeful that in 25 years, and again, this was back in 2003, that the use of race might not be required. But as we look now, 20 years later, we hear Justice Thomas stating that he's heard the word diversity in his dissent, he states, but yet he doesn't have a clue what it means, right? And so the court in this case, overturning again strong precedent, and it's quite troubling. They held that there is no compelling state interest as articulated by Harvard and the University of North Carolina. There's no compelling state interest in training future leaders, cultivating knowledge, new knowledge based on diverse perspectives, promoting a marketplace of ideas, and preparing engaged and productive citizens. They thought those goals articulated by these universities just could not survive strict scrutiny. And so Justice Ketanji Brown Jackson, who recused herself from the Harvard case because she sits on the board, but she did write an opinion, participate in the University of North Carolina decision, and she says that determining race is irrelevant in law does not make it irrelevant in life. And to your point, Attorney Lee, there's no such thing as, quote, race neutrality. And they throw around the term colorblind society. That's a fiction as well.
Yeah, and for the listeners, I'd like for you to start also watching our show on www.bigsradio.com. That's www.bigsradio.com. And our call-in number is 833-653-3529, 833-653-3529. And join us each week also on bigsradio.com, and you can see the replay of all our shows also on their website. Now, about this decision, the reason I think that it's so profound is that they exclude the military, but history tells me that the military was probably the first agency in our country to desegregate, I think in 1955, because up until then, like when my father was in the military, it was segregated. And so we have this background of segregation in our government, but you got to remember, segregation was the Supreme Court law. So our law by the U.S. Supreme Court, dating back to the case of Plessy versus Ferguson, it, basically say separate but equal was fine, but the problem is that they did not give Black folks the same rights as citizens as white. And this process played out even in the 60s. So in the 60s, if you were in the South, for example, they had separate water fountain for you to drink out of for colored folks. You could not eat at restaurants and things like that. And with this background, they decided that at some point that maybe the 14th Amendment means something. Equal protection in the law mean also equal protection for Black folks. And because of this equal protection, now in this decision, what they said that was troublesome to me, Chief Justice Roberts wrote, eliminate racial discrimination means eliminate all of it. That's what he says in the opinion. Eliminate racial discrimination means eliminate all of it. The same court have diverted the cases that dealt with discrimination in employment by Black folks. The same court, and with the judges that are appointed, it's almost impossible to get a racial discrimination case to trial for race. You can do it for sex, you can do it for age, but you can't do it for race. If you're a Black person, it's almost impossible to get a trial in a racial discrimination case in our court system. So this affirmative action decision could have far-reaching consequences across the board. Like, for example, corporations who had a bad history of hiring Black folks, now they have diversity departments. Used to say equal opportunity affirmative action. Well, maybe it won't be equal anymore. And certainly not affirmative action. Now, once the courts say affirmative action is no longer the law of the land that's illegal, that will lead, in my mind, to a more divided country and a more racist country. And so that's a point of beginning on this discussion. That is that this decision could have far-reaching consequences. And we'll go to our first caller, Imhotep. You had a question or comment for us today?
Yes, how you doing, Brother Nate? How you doing today?
Great.
Good. Just a couple points I wanted to point out real quick on this whole thing. I learned talking to my mother what it is, and you're right. They exempted the military, but we also found out that Judge Mathis put out a scathing dissent of this whole thing. And good logic, people, I commend anybody listening. Go pull up Judge Mathis's conversation about this yesterday and his logic. He also said that they excluded athletics too. So, because consider that, we know that in college football, college basketball, track and field brings in billions of dollars that funds all these universities. Ivy Leagues don't pay scholarships, but all the rest of them do. And so, of course, no one, and white people will not admit this, they don't even want to see their own people playing the sports because they don't feel entertained by them. So they left out athletics too. But I think the biggest detriment to one of the decisions was the postal. My mother worked at the post office for a few years before she became a lawyer, and she did hiring there, she told me. And so that decision with the post office, I think, is going to have far-reaching effects. You know, I'm in healthcare, and most healthcare facilities, hospitals and stuff, 24/7, restaurants, steel mills, you know, various things that are all 24/7. So what are you going to have? A lot of people come in now. Buddhist religious days Tuesdays, Juma Muslims Fridays, Jews is Saturdays, so Christian Sunday. So you're going to have everybody coming in now saying, hey, you got to accommodate my days off. I got to go to worship, so you got to accommodate my day. I think that's going to be a quagmire of things they've done. But my mother's opinion was that a lot of this she thinks is going to come back and bite them in the butt. And then I just read a piece from the NPR. They just concluded a 25-year study on when California banned Prop 209 and banned affirmative action, and how long it took for them to catch up. Techniques they used, to get a diverse population back on these campuses. And so that's a great piece, people. If you go look it up at NPR and the results of what they had, and they figure that they're probably going to see the schools do a lot of other different things to try to get around that. But it shows that we have a Supreme Court that's political. They're bought off. They're getting paid by billionaires. And I want to applaud Ketanji Jackson for lighting into Sambo Clarence. Uncle Josiah Henson was a hero. People, let's stop using Uncle. Sambo and Quimbo were the ones who told on him, so we use Sambo. That goes back to old school. Sambo Thomas, I applaud her for tearing into him, because these decisions are anti-people. The same thing with the student loan. That's anti-people. And you just don't understand it. You know, you attack January 6th about an election, but then you won't go stand up for the very things that help people, especially student loans. It helps all people. So it's just a sad day. People around the world look at it and look at things. It's like they can't believe what's happening, but we can. We know that since Citizens United, the system has been bought off, it's paid for. And even George Bush, too, said that he thought legacy admissions should be stopped when Roland Martin questioned him. So what's your opinion of those legacy admissions, too? Thanks for taking my call.
Well, I could have Attorney Banks, but I got a really strong opinion about legacy admission. So, Attorney Banks, you have a response to the legacy admission issue?
Well, I think legacy admission needs to be strictly scrutinized as well, because that expands exclusion rather than promotes diversity. And so what do you think, Attorney Lee?
Here's the problem. I served on my law school board and I raised money. And on the board, we had 15 members of this board. And as I recall, I was the only Black. Now, by being on this board and raising money, it would have given me an opportunity to give my own kids the ability to get into law school and get a scholarship, I guess, affirmative action type, legacy. And so the idea is that you work for the university, raise money, then legacy, then give your kids the ability. Well, neither one of my kids went to the University of Georgia, so I got off the board. But the problem with that process is that legacy doesn't typically involve Black folks. So in other words, the reason why the legacy admission is bad is that there's no diversity on these committees. It's very little, because we historically, since we're not part of the process, like you take my law school, if they didn't admit Blacks only a small percentage and just started like in the 60s, after over a century, then the legacy admission means nothing to Black folks. So it means that affirmative action for white students, because see, all these folks that apply to the law school, they meet the minimum qualification, maybe 90-some% of them. And so it's very competitive. The University of Georgia admits somewhere between 10 to 14% of the applicants. So they get thousands of applicants each year, and they offer admission to no more than 250 students. They will get 3,000 applications for admission. And so it's very competitive. And so when that occurs, if you are on the board, you could always call the admission officer, hey, that's my kid. So the people that makes the decision, the thing about it is that you actually have the ability to talk to them. Okay, now we'll take one caller, producer. We'll take one caller real quickly. Okay, from the radio station. You have a question, caller. Go ahead.
Hello, Nate. Can you hear me?
Loud and clear.
Yeah, this is Pierre. So, what does that mean for historically black universities that some historically black universities have to actively recruit minorities, white students or whatever, or other students, so that they can maintain their state accreditation and some of their state funding or whatever? So what does this decision mean for them? Do they have to continue to offer minority scholarships to, like white students or Indian students or whatever, or can they now just do away with that? And are they no longer obligated to have to meet, a certain percentage of minority recruiting? And what do you think this will do? You guys brought up the sports aspect. Can you go over that again? Because I can't imagine what self-respecting black kid would want to go to the University of Georgia if he's only going to be there for football, But thanks for taking my call.
Wait a second, Pierre. The University of Georgia Law School is traditionally one of the top 20 law schools in the country. And so the graduates pass the bar, like look at the statistics, like 99% of the time, the first time. So in other words, you want to go to law school that puts you on the path to success. And I thought that attending a law school, a top 20 law school, was very beneficial. You have the same professor there they have at Harvard and Yale. Their professors come from the Harvard, Yale, Stanford. So in a nutshell, you want to get a quality education, but the problem is that educational opportunity is not typically afforded to Black students, and that's the problem. And so your second part of your equation is that, well, how did that affect scholarship? Well, that's a question that's one of the unknowns. And here's what I mean. If I was still on the board of the law school, I would make sure that the money I raise, like when I was on the board, I specifically raised money for BALSA. And so BALSA is the Black Law Student Association Law School. And so I raised enough money to pay for the BALSA trips, extra scholarship money, and I would have money designated just for the Black students. But you have to have somebody on the board that actually raises money. I raised a record amount of money for my law school, and then Chester Davenport, I recruited him. He just shouted everything I'd done. Chester Davenport, the first Black to attend the University of Georgia Law School, became a billionaire. And but he did not participate until I recruited him. So what the point of this is that we have the ability to raise money for the institution. And if you did that, then you could have some say in the outcome. But by and large, we don't have that at the typical law schools. I mean, I forgot the total number of law schools in the country, but it's just not law schools. It's medical schools, it's dental schools, it's your professional schools, I think is going to be the ones that are going to be affected the most. And that's my concern, Attorney Banks.
And the question becomes, can universities be racially diverse without affirmative action? And our experience suggests the answer is no. We know that 9 states, including California, have banned affirmative action in university admissions. And We see that diverse enrollment is down in those states that have banned affirmative action. And after these kind of bans, and I want to call out very loudly to potential students that may be listening today and or their parents, that we should be very, very clear that students should not be discouraged and choose not to apply. We are not going to turn the clock back in this case. This ruling does not affect the goal of achieving diversity, and it doesn't limit institutions' outreach, engagement, retention, or other strategies to promote diversity. We've heard statements from Harvard. We've heard the statement from President Biden. There are other factors that can be taken into consideration, and I believe they will, that these universities will adjust their policies to promote diversity based on, again, a number of factors, including where you grew up, your geographic or regional location, your socioeconomic experience, your unique experience. Justice Roberts included that students can, in their essays or in their application process, that nothing in the opinion should be construed to prohibit applicants discussing how race and overcoming adversities in life have affected them and through part of that application process. Interestingly, President Biden said 3 times in his statement that discrimination still exists in America. Discrimination still exists in America. Discrimination still exists in America. He stated that 3 times.
That's profound. Now, one of the things I need to point out that, in my personal opinion, there's over 6,000 colleges and universities in the United States. And I think that because there are so many colleges and universities that you see a lack of enrollment in certain areas, but there are certain specific things, though, I think that are important that may help the situation slightly. Like, for example, the football powers in terms of Power 5 schools like the Southeastern Conference and Big Ten, they rely on African-American athletes in order to compete for national championships each year. A part of the recruiting process is the campus life. So when these young men, and now what fund athletic programs in these Big Five, number one is the football program. Number two, the basketball. The other programs are not the really revenue producers. When I was on the Georgia board, the University of Georgia football team generated $125 million a year, $125 million. You know, so that funded the entire operation. I'm not sure what they do now, probably close to $200 million after winning the national championship. But the point is that fund out the operation? Well, in order to continue to recruit talents to compete for national championship, you have to have diversity on campus, that when these young men come to visit, they need to see people look like them in order to have people to socialize with. And so part of the college experience also is a socialization. You know, it's things that you do with other young folks. Now, the corollary to that, of course, when I watched University of Mississippi and I watched what happened on their campus, I watched them burn flags and riot when President Obama got reelected. And I wonder, why the hell does any of those Black athletes go to this school when you see something like that? So that march and outward racial process didn't deter some elite athletes from going to that school. Well, in my situation, it's been a no-brainer. If I seen that on TV, I said, these people go to hell. I would never even think about going to a school like that. So I think that the only thing that's significant about this is that athletics may be a slight buffer, but the real problem that I see with affirmative action relates to professional schools. We have a lower enrollment in these schools that offer advanced degrees. It's more competitive to go to a professional school than a regular college, unless you're talking about MIT and some of the elite schools like that, but professional school admission is tough. And that's my problem, Attorney Banks. I think that this affirmative action going to drive down the number of Blacks that are going to our professional school, like the medical schools, which is difficult as heck to get into already. The law school, the PhD program, and the scientific, like the engineers and things like that. I think that we're going to see a slower increase in the number of Blacks attending those professional schools.
No question about it. And that, Attorney Lee, is the situation today. The practice of law is one of, as you know, the least diverse professions in terms of the representation in comparison to our population representation, as well as in the practice of medicine, another area that is least diverse. And so this has huge implications, and they exist today in terms of the quality of medical care and in terms of the quality of medical care and access to legal services. And this decision potentially only makes it worse. But again, this is the importance of voting. If these decisions don't make it clear to the citizens of the United States why it is critically important to vote in every election, I don't know what will drill that message home.
Well, I think that is very profound, that what we're seeing occurring highlights the fact that the next election that we're able to vote will be the most important one that we ever have. And the one after that will be the most important. Next year in 2024, we have the presidential election. This year in Indy, we have a mayor's election. And we have so many legal issues that are on the ballot now. Even in our local mayor election, we have one candidate who shows his company don't have a single Black person in any of his ads. It's insulting. And he says that we need to fight crime, but yet he advocates for the NRAs, give everybody, even lunatics, guns. And so these elections are so important. So is serving on jury duty, but they're equally important. But these elections will determine the fate of our country. Our country, with these type of decisions, I think is making the country more racist. I think that these programs of affirmative action, they were meant to try to cure some obvious legal improprieties. Our country legal system said that segregation was okay. The denial of access to Black to colleges and universities was okay. And now, you know, everybody thinks that the Brown case in 1954 ended desegregation. It did not. In my personal experience, that decision that was handed down in 1954, my high school was desegregated in 1969. So it took 15 years for that decision to ripple into my high school in South Florida. So just keep that in mind. And I'm not sure how fast this current decision will start having immediate effect on our system. Do we see a dramatic drop off in professional enrollment in 2023 or 2024? And I'm really concerned about that. And I anticipate, though, that every professional school admission is looking at these decisions, because you took on the big guy, Harvard University. And that decision was disturbing because Harvard, although they work very hard to have diversity, they don't have a lot of Blacks there to start with. And so these type of decisions, it dealt with the fact that the Asian student want to have more presence. But we don't replicate or represent the population that we're serving, particularly in the legal community. Like Attorney Banks said earlier, I think that one of the most discriminatory profession is the legal profession. I think that in our state, law firms were basically desegregated in 1987. We started to push to desegregate law school in 1987 in Indiana. So we have a very short history of racial parity in this situation. So I just think that the idea of having an elimination of affirmative action is just bad for our country and bad for our state.
Attorney Lee, I want to call out Renee, who I see her comment in the chat box, and she's absolutely right that universities and colleges, they have to be creative if they're serious about achieving diversity. And I agree with that wholeheartedly. There's a number of factors, and we just cannot abandon our commitment to diversity, period, full stop. And so the universities have to continue to look at a number of factors, including, socioeconomic status, where applicants live. Again, there's nothing that prohibits applicants from discussing how race and the things that they have and adversities that they have overcome, in their lives, in their application, be it through discrimination, inspiration, as Justice Roberts stated, or otherwise. We just cannot go backwards. And this court is demonstrated in these decisions that they're just not in the mainstream. Their opinions are just not in the mainstream.
Now, one of the things that I see our chat room is lighting up. Biden is doing a great job of filling federal judgeship. You need to keep going because I see changes coming for Supreme Court. Well, the problem though is that those federal judges are lifetime appointments, and the Biden administration has done a great job, but they still get a lot of pushback because the slight majority we have in the Senate, because Senator Feinstein was on medical leave, it froze all those applications for about 3-4 months. And so we're behind now on the appointment process because we did not have a majority vote on the selection committee, on the judicial committee in the Senate. And so keep that in mind. Now, the other issue, this affirmative action is some personal, and I believe very strongly that but for affirmative action, regardless of your background, your academic talent, you would not be able to get in these professional schools. My school, I know very, very clearly, the only reason I ended up going to the University of Georgia because they recruited me because they were trying to get some qualified Black students. They were trying to get people that met the academic background and the test scores. And for that reason, I got a full scholarship. I never would have been able to get a scholarship to attend law school, but for affirmative action. That's clear. It doesn't matter how qualified you are. It had to do with the fact that you weren't welcome there at all up until the 60s, until they decided to desegregate the law school. And so keep that in mind. Now, there's so many cases that came out until the student loan case, Attorney Bank bothered me. President Joe Biden, who has advocated very strongly for building the middle class, increasing the middle class, give opportunity to the middle class. So he's been pushing, and they've had some significant legislative success in making opportunity available for the middle class. But one of his key programs is that he worked very hard, and he issued an order to basically wipe out $20,000 of student loan debt. Now, a lot of people were critical of this, saying that, well, I paid my student loan, why don't they pay theirs? Well, you got COVID money, you got farmers get subsidies every day. And so they eliminate the idea or ignore the idea that all these folks are getting government benefits, but they're upset because some students are getting $20,000 debt reduction. Now you got to remember, on student loans, it's not the amount of the loan that caused the problem. If you had a $100,000 loan and the interest rate is 8%, the interest on the loan will cost you, what, $750 per month. So these students, it's not the fact that they borrowed money, it's just the interest rate on this debt is so severe until they'll never pay the debt off. And back when I first started practicing law, you could bankrupt student loans. And then they made an amendment to make it almost impossible that you had to show hardship. So I did, back in the 80s, I did some trials on hardship, and I was able to get some reduction, but it's very difficult. So student loans is a big deal. These students, a lot of these young folks, they incur substantial debt. And oftentimes their student loan debt looked like a home mortgage payment. And the debt is based on the fact, one, on the borrowing amount, but number two, on the interest accumulated. And so because of that, we have to work hard to make sure that we reinstate this process that Biden tried to do. We need to give our folks, students, some debt relief. I don't know whether or not you were able to go through college or law school or Attorney Banks loan-free or debt-free, but most folks I know just ran up massive debts. And I thought that this was a great idea to get rid of some of this student debt.
Absolutely, Attorney Lee. And so the issue in this case was whether or not the president had the authority under the HEROES Act to grant this loan relief. And it's clear that under the act, the president did have the authority to grant student borrowers this relief. And this is a huge decision. It impacts 25 million people. 16 million people had already been approved, and the checks were just, being prepared to go out before this decision came down. And to your point, this speaks to the hypocrisy. Many members of Congress received payments through the Paycheck Protection Program, the PPP, but yet they would deny students some debt relief in this situation. And so it's a horrible decision. And as President Biden stated, and by the way, there was some criticism of the fact that under President Biden's program, a student could have, a former student could have up to $10,000 of debt relief and $20,000 if in the case of a Pell Grant. And this decision will impact 50% of Hispanic students and 40% of African American students as well. And as we heard from the president this week, that although this decision is wrong, that he's going to now use other authority in order to get this debt relief to the American people. He's going to be looking at the Higher Education Act, under which there is congressional authority, as in the Higher Education Act, by the way, to compromise, waive student loan debt. And he's working to do just that. And so we just have to find other pathways, as in response to the affirmative action case, to help relieve student debt and to ensure diversity in admissions to these schools of higher education, Attorney Lee.
Yeah, one of the things that concerns me is that a lot of young folks who are just trying to get a leg up in their education so they can have the ability to earn a living, because we educate ourselves beyond the high school level, is that we're trying to build a better lifestyle. We go to college because we're seeking methods or ways to make more money. We go to college because we're trying to spend our knowledge base, center of influence, a lot of different reasons. But college ain't free. We know that. And majority of people don't have rich parents. Then they have the parents that set aside a trust fund to pay all their college expenses. And because of that dilemma, if you were born into a household that didn't have a lot of money, you're going to need the student loans in order to matriculate through college or university. And because you need that, I think that it is wrong for the government. In this case, Republicans, for whatever reason, came up with this notion that, well, we have people that pay the student loans, and so they're being punished if the other people don't have to pay. Well, I got news for you. I see our callers, we have some of the most intelligent listeners of any show. They point out that the PPP money wasted billions and billions of dollars. And we know what 90% of that money went to white persons, white businesses, over 90%. So it was okay to give people $1 trillion or almost, in PPP money. But you can't give help to folks who are trying to get out of poverty. It's insane. Now we'll go and take one caller. Caller, you have a question or comment for us?
Good
Hello?
morning, Council. This is Alvin Washington calling. First and foremost, congratulations on getting a more direct connection to the show. I think a lot of people that have been on today, I know they probably haven't told you, but I think they appreciate that. Secondly, I know the topic du jour has been the striking down of affirmative action in the admissions of various schools, whether it be PWIs, HBCUs, what have you. Now, we already know what it means for PWIs. What is the unintended consequence that this ruling now has on HBCUs? Because I'm of the mindset that potentially you might see a slow uptick of Caucasians coming to HBCUs.
Well, That's a fascinating thought process. I don't know. Attorney Banks, you have any opinion on this issue? That's kind of complicated.
I think so. I think we have to see. I think that when you look across HBCUs, that there is a population of whites and other ethnicities that are attending these schools. I think there probably has been an increase in what I'm just going to say modern times, if you will, of various ethnicities attending HBCUs. But I think that's something, as the caller, mentions, we're going to have to watch that and see what happens.
Well, it's complicated.
And then the thing about it is, you're talking about state-funded HBCUs as opposed to privately funded HBCUs, because the admissions process is a little bit different. And I'm looking at possibly places like FAMU, South Carolina State, North Carolina A&T, Hampton, Norfolk State, so on and so forth. They start seeing something like this, and now you start seeing those youngsters that want to, especially with the influence that Deion Sanders has had the last couple of years, they may want to partake of this, and because you got state-funded schools, they just might.
It's complicated. Well, thank you very much, caller. That's very interesting. Thank you very much. Okay, next caller. Okay, producer. We have one final caller we could get. A caller, you have a question or comment for us today? Oh, I think we lost our caller. Okay. Attorney Bank, I think we lost our current call, but one of the persons sent us a text that says that HBCUs will no longer be able to incentivize non-Black students to diversify their student body also. No race-based admission across the board, according to SCOTUS, Supreme Court.
I think she's absolutely right. The caller's absolutely right. This works in the reverse as well. Your thought, attorney?
Well, see, I don't know. The thing that bothered me is that, the concept of separate but equal had to deal with the fact that they would give 3 times as much revenue for white school versus Black school when I was growing up. And so the problem I have today is that I looked at the financial wherewithal of the HBCUs when they were talking about athletic programs, things like that. And when I reviewed that, they show the total revenue base. And so at the top of the list on the Black college university, their total revenue for athletic budget, say, be 15 to 20 million. And I looked at schools like Alabama, Georgia, 200 million. So the point is that I think that we still have an unequal system because the Black college and university just don't have the money that the white universities are having. Therefore, you're not going to have the same access to certain type programming in the scientific community and things like that. And so that's what I'm troubled about, is that we don't have the same resource allocation to those universities. And I think resource allocation is important. You take schools like MIT, who's got billions of dollars in endowment fund, they can fund all kind of projects and things like that. You don't see that available at a lot of Black colleges and universities. This is my thought process.
That is so true.
Yeah, we have to close out today. And I'd like to thank everyone for calling in today. And I thank our producer and, of course, our listeners. Please join us next week. And also, don't forget, you can also follow our show on bigsradio.com. And I look forward to talking to you next Saturday. Until then, may God bless and keep you. Take care, everyone.
Thank you. Have a great day.